morning, Your Honors. May it please the Court, Richard Harrison for the plaintiff, Ann Weintraub. Ms. Weintraub is with me at counsel table. She is also a member in good standing of the Florida Bar. We're here this morning because no private person should be compelled or coerced to divulge private financial information or details of her health or medical condition or that of her family members, or intimate details of her personal relationships as a condition of not being libeled by the press. That's what happened to Ms. Weintraub. Ms. Weintraub's a real estate lawyer in Sarasota. She purchased 3 residential properties over about a 2-year period in 2005 and 2006. They were all financed by SunTrust Bank. They were all financed with standard Florida residential mortgages, all of which contain a provision that says this will be your primary residence. You'll move in within 30 days, and you'll live there as your primary residence unless, and there are 2 exceptions. 1, if the bank waives that requirement, and 2, if there are extenuating circumstances beyond the borrower's control. That's in every mortgage involved in these transactions.
Pardon me.
And what happened is, Sarasota Herald one day woke up and literally found an anonymous document dump on its doorstep that contained these mortgages and had a note that said essentially, hey, this looks like mortgage fraud. How can there be 3 primary residences? That's how this all started. The Herald begins working on that article. They contact Ms. Weintraub sometime in January, start asking her for comment. She met with them initially to find out what they were talking about. And then over the next 2 or 3 weeks, there was a barrage of emails from one of the reporters to Ms. Weintraub, essentially demanding an explanation. We want to see your financial information. In one email, they actually demanded, you need to bring somebody from Sun Bank to explain to us what happened here. Well, no, Ms. Weintraub does not need to explain her personal financial situation to the Sarasota Herald. Those extenuating circumstances beyond the borrower's control might very naturally be some very personal things. If we sat down and made a list of what those might be, it could be a turn in your financial circumstances. It could be a serious health or medical issue. It could be a life-changing decision, a marriage, a divorce, an affair, who knows what.
If we're going to get into supposition, it could also be a 1-sentence document that says we hereby waive that requirement.
That's right. Or it could be a simple waiver by the bank. The fact of the matter is, the bank refused to talk to the newspaper because banks don't talk about their customers' financial information. Ms. Weintraub refused to provide the explanation the newspaper was demanding because she shouldn't have to reveal her personal life to the newspaper for 2 reasons.
So
One,
not suggesting that your client is required to respond to these inquiries. The record does not indicate that there was a waiver or that there were extenuating circumstances.
the record indicates that neither the bank nor Ms. Weintraub said one way or another whether there was a waiver.
And there's nothing else in the record that would suggest that there was a waiver or extenuating circumstance?
There's nothing, for example, there's no written waiver recorded in the public records. No, sir. There is nothing concerning whether or not there were extenuating circumstances.
I guess what I'm getting at with that is that having read the article a couple of times, I just wanted to make sure that the article doesn't fail to mention something that is out there somewhere.
No, let's be clear. I appreciate that question. Ms. Weintraub never discussed what those extenuating circumstances might be. She declined to do so. And if you think about it, frankly, that's a pretty compelling situation to be in. If you don't discuss your personal financial situation, whatever it may be, financial, medical, something else, you end up with this article where you're accused of committing mortgage fraud. If you choose to divulge whatever those extenuating circumstances might have been, financial, personal, medical, whatever the case, Well, then all your neighbors are reading about it in the newspaper article. So how can that be right? That's what happened here. When Ms. Weintraub refused to talk about what the extenuating circumstances might be, the Herald wrote a 2,100-word article on the front page of the Sunday paper, carrying over to an entire inside page, the only fair reading of which is that Ms. Weintraub, an attorney, committed mortgage fraud. The article, of course, is in the record in reduced 8.5 by 11 size. It's a little fuzzy to see. I do have a blow-up of it, which I would like to display, but I talked to counsel. I won't do it without the court's permission. I think
we have a sense of the article.
Okay.
I don't think you have to worry about that.
All right. Again, you know, this is what she woke up to one day. So this is why we're here.
Well, the judge seemed to pin his ruling on really two things. First of all, he determined that under the law that the fair reporting privilege provided that essentially this was a reporting on matters of record, mortgage documents, and therefore was not actionable. Why don't you start by addressing that, and then we'll get to the part about the individuals who were quoted.
Right. And there are actually several other things that the trial judge decided that are important, but let's start with the fair report privilege. We're not disputing that the privilege exists. We know what the privilege is. The purpose of the privilege is to allow the media to report on official proceedings so that the public may be informed as to the workings of government. That's out of the Ortega case, 3rd DCA, 1987. That's the purpose of the privilege. How does it work in practice? The way it works is, if some government agency or some government official makes a statement or writes a report or issues some document, and the media then reports fairly on the contents of that statement or that document, the media is protected even if it later turns out that something in that document or statement was incorrect. That's why the privilege exists, to allow the media to report on what the government says or does without the risk that they're held accountable for the government's mistake should there later turn out to be one. We have no quarrel with that at all. There's no government statement or report anywhere in this case. There's no government official involved in this case. The only public official remotely involved here is the clerk of the court, who did nothing except perform the ministerial statutory function of recording the mortgages. They're not reporting on something that the clerk said or did. The difference would be if the clerk of the court wrote a report that said, hey, this looks like mortgage fraud, and they reported what the clerk said, the privilege applies. That's not what happened. There's no facts here that compel the application of the privilege because they're not reporting on anything the government said or did, number one. Number two, even if somehow the privilege applies, the privilege only would apply to what is in those mortgage documents. What's in the mortgage documents is what's in every mortgage document. The amount, the dates, the property description, all the other terms of the mortgage. To the extent they reported that factual information accurately, which they did, and we've never said they didn't, fine, but they went far beyond what's in the mortgages. They wrote an article that said, this is mortgage fraud. They took the raw data of the mortgages, put it into their blender, hit the button, and poured out a big old cup of fraud. There's nothing in the documents that says anything about fraud. So even if the privilege applies, they went far beyond anything covered by the privilege. The privilege does not protect their own opinion about what those facts mean, or their own conclusion, or their own determination that fraud has been committed. So our position on fair report is, doesn't apply. And when you look at the cases that they cite, by the way, Rasmussen, the reporting was based on a criminal information executive orders of the governor, a plea agreement, and some government reports, all things created by the government. In Stewart, it was based on a press release by the sheriff. No problem there. In Woodard versus Sunbeam, it was based on an FDLE report. Again, we agree, the privilege applies. There was another case that I think this court may have decided, or perhaps Judge Williams did in another matter below, where the reporting was based on a report from ACA, the Agency for Healthcare Administration, that was critical of a hospital and a particular doctor. Court properly said, when the media accurately reports the contents of that report, the privilege applies. There's no report here. There's no statement by any government official. So they took some mortgages, which we know are recorded by the clerk, and they looked at them and said, aha, this is fraud. Privilege doesn't apply. The other thing that happened, and really it colors some of the other rulings, the defendants, primarily the newspaper and the television station, filed motions to dismiss or alternatively motions for summary judgment. The court considered those as summary judgment motions. The court found that Ms. Weintraub's not a public figure. That immediately colors everything that happens after that, because she's not a public figure, it's a negligence case. It's a negligence standard that applies, not the higher constitutional malice standard. So having found that Ms. Weintraub's not a public figure, and therefore it's a negligence standard, the court then found no fault on the part of the media. In other words, no negligence, even though nobody had raised the issue of negligence in their motions. The defendants never raised on summary judgment, we were not negligent. Why? Because they were arguing that the higher malice standard applied. So the court decided the negligence issue, which one is a jury question, and two was never raised in anybody's motion. It then considered this notion of newsworthiness. The court has a section in its order where it says, well, it has something to do with the mortgage crisis, therefore it is newsworthy. Supreme Court of Florida in Miami Herald versus Ain said, when you were talking about a private citizen, someone not a public figure, we don't care about newsworthiness. Doesn't matter. Another error. The court decided that there was no falsity, not a single falsehood anywhere in this article, but it never considered or addressed any of the many specific statements we allege to be false. It just said no falsity. Well, that's a jury question too. And then it did the really astounding thing. The trial court determined as a matter of law that the article was not defamatory. And what that means when you decide that as a matter of law is that there is no possible defamatory meaning or connotation that any reasonable reader could take away from this article. The trial court decided that as a matter of law. That is so astounding because none of the defendants even argued that. The notion that that there was no possible way for this article to have any defamatory meaning is absurd. It's so absurd they didn't even argue it. But somehow the trial court decided there's no possible defamatory meaning here. We talked about the fair report privilege. Our view is not that the privilege doesn't exist, but that the privilege doesn't apply in this case, or if it does apply, the newspaper went far beyond whatever will be protected under the privilege. And then the court held that 3 specific statements in the article attributed to specific so-called experts, people that the Herald decided were experts, were pure opinion and therefore not actionable. And I think there's a bit of a bone of contention on that issue because in the Herald's brief there's a footnote that seems to suggest that the court's finding of a non-actionable opinion was not limited to those 3 specific statements of those so-called experts, suggesting that they think the whole article is opinion. But when you look at the trial court's order, it's very clear, because the trial judge says so, that he was talking about those specific comments beginning at page 668 of the record. The court talks about those three specific commenters is what the trial judge...
Are those three specific comments what you're claiming is false?
Yes, among a lot of other things, but yes.
What else are you claiming to be false? Because I didn't understand that you're claiming that the fact that the mortgage documents each contain the request or the notation that they're to be used for a primary residence, that isn't claimed to be false, is it?
Oh, no, absolutely not. Again, to the extent they reported the contents of the mortgages, they did that accurately. The dates, the amounts, the properties, the banks, and the language of the primary residence clause.
So the article had simply said, that we found these mortgage documents, there are 3 of them, they all indicate primary residence, this seems peculiar. We called Ms. Weintraub, we asked for comment, she declined to comment. Any problem with that?
Well, it depends on what they actually said. If that was the extent of it...
Just that in essence.
I would say no. If that was the extent of it...
So is it the real crux of your complaint is what these so-called experts said that was then put into the article?
It's not, I want to be clear, it's not limited to what they said, because what they said was simply a part of this overall very lengthy article where the Herald says this is fraud.
Where did they specifically?
We'll start with the lead. One of Southwest Florida's most prominent real estate lawyers financed more than $1 million worth of personal real estate during the boom, simultaneously claiming all 3 homes as her primary residence, which experts say violated her mortgage terms. Violating the mortgage terms.
Well, is that,
hang on one second, Mr. Harrison. You're at 17 minutes. I certainly want you to answer this fairly. You did not tell me if you want to reserve any time for rebuttal. What I'm going to do, I'm going to go ahead and reserve for you the 3 minutes.
Yes, sir.
But go ahead and finish answering this question.
And I won't use up the rest of your time. So is that's part of your...
Again, it's not limited to those 3 comments. The entire article, and the court has to consider the entire gist of the article, is that you take these 3 mortgages, which are just pristine mortgage documents. It is the Herald who decided, using as a part of it their self-selected experts, that somehow this is fraud. And of course, accusing someone of a crime is defamatory per se. Accusing a lawyer of a crime is defamatory per se. So thank you for reserving my rebuttal time, Your Honor.
May it please the court. Your Honors, my name is Charles Tobin with the law firm of Holland & Knight. I represent the Sarasota Herald Tribune, the reporters and the editors who are defendants, associated with the Tribune. Carol LaCicero with Thomas and LaCicero represent a separate defendant, LDB Media. She and I have agreed to divide the argument 15 minutes for me, 5 minutes for LDB Media. There are 2 other defendants who appeared in this appeal, the Lacefield defendants, Gary Lacefield and Lacefield Consulting. They have deferred to our brief. They did not brief separately. They're deferring to our argument today. As well, there's a defendant, Matthew Weidner, and his law firm, Weidner and Associates, PA. Their counsel, Mr. Ray Robin, is present today, but they've also deferred to us both in briefing and in argument. And so with those preliminaries, Your Honor, we would ask that the court affirm Judge Williams' ruling for the 2 reasons, Judge Black, that you articulated, and that I think Mr. Harrison has conceded, at least as to the fair report privilege. This was a fair and accurate report of Ms. Weintraub's history over a 16-month period with regard to 3 properties in 5 different lending instruments that were recorded in the official records of representing that she would occupy each property as a primary residence. Mr. Harrison concedes, Ms. Weintraub concedes we accurately reported that. We included in our reporting in several points the language that extenuating circumstances and that a written waiver, which didn't exist, and there were no extenuating circumstances on record, and we reported that as well. Extenuating circumstances and a written waiver would relieve her of that obligation, and when we asked her about extenuating circumstances, she wouldn't give us any information about that. With all of that in the article, in the record, with the record containing Volume 2, page 287, Volume 2, page 184, Volume 2, page 222, Volume 2, page 311, Volume 3, page 520. With all of that material in the record, Judge Williams correctly compared the record to the article, and he held that for those portions of the report, the article, that talked about the contents of her mortgage, it was a fair and accurate report, and it was protected under this court's ruling in Rasmussen. I believe, Judge Silberman, you were on the Rasmussen v. Collier County Publishing Company panel. That's from 2006. The other DCAs in Florida are Uniform Honor, Woodward versus Sunbeam Television in the 4th DCA. We've also cited the Stewart versus Sun Sentinel case, also in the 4th DCA. Florida law is uniform on the fair report privilege. The judge was absolutely correct on that. Mr. Harrison's argument to get out from under the privilege, as I understand it, is these records are of a different kind because they do not reflect something the government itself created or released. He's arguing for a constriction that does not exist currently in Florida fair report privilege law. He's arguing for a privilege that conflicts with this Sunshine State's broad public access law that gives the public the right to go in and take a look at documents. He's also arguing bad public policy. These are not merely documents that are ministerially recorded because the legislature decided they should be recorded. These mortgages form the basis for title searches. They form the basis for credit information and credit history. They form the basis for mortgage foreclosure actions. They form the basis, the very basis for official actions that people take, and that in fact were taken in this particular case as to Ms. Weintraub. Part of the reason this was newsworthy, and the article reports
What
this.
official actions were not taken?
I'm sorry, official actions that were taken.
You just said that there were official actions that were not taken in this case.
No, I'm sorry. Maybe I misspoke, but what I meant to say, I'll say I misspoke. What I meant to say, Your Honor, is that in this particular case, these mortgages form the basis for the foreclosure proceedings, because not only did Ms. Weintraub...
You're saying official actions that were taken.
Correct.
That was what you were saying.
Correct. Either I misspoke or the judge misheard the not. Official actions were taken. Liz Pendon's documents are in our record at Volume 2, page 239, Volume 2, page 269, Volume 2, page 339. She was foreclosed on all 3 of these properties that she represented without anything else in the record indicating to the contrary were going to be her primary residences. Moreover, those foreclosures resulted in short sales, also of record in the proceedings, that the bank foreclosed on that cost SunTrust Bank something on the order of $500,000. So these are not, and my point is, he's arguing for an exception that, first of all, doesn't exist in the law. There is no case in Florida that says that we have to rely on the government to dole out the records to take official action such as a complaint or something like that in order for the privilege to apply. And in Florida, reporters and citizens have the right to go into their courthouses, look at and talk about public documents on a daily basis. And in this case, these particular documents were not just ministerially recorded, they were acted on in a foreclosure proceeding, which was reported accurately in that article. So Judge Williams was correct on the fair report privilege issue, and there's nothing that the court has heard today or seen in the papers that should cause this court to be the first one in Florida to retreat from the strength of the fair report privilege. And in fact, this court recently, or it's cited in our record about 2 years ago, Ms. LaCicero was representing the Sarasota Herald Tribune in the Angel Astro versus Sarasota Herald Tribune case. Judge Crenshaw and Judge Black, you were on the panel that PCA'd, coincidentally, Judge Williams' ruling. Those were records filed, I believe, with the Department of Health Services by a citizen. It started out with, a citizen's letter, a private document, if you will, a handwritten non-government document filed with the government. That's the functional equivalent, or at least analogous, to here, and in that case, you all PCA'd a decision based on the fair report privilege. So I don't think there's any credible argument under the privilege portion. Now let's take a look at the other portion, turn to the other portion, Your Honor, that you mentioned, and you're absolutely right. On page 2 of the summary judgment, Judge Williams said fair report privilege applies to the documents. Opinion applies to the commentary of the sources, the so-called experts, the people the Herald Tribune went to, who were mortgage fraud examiners, who were an attorney in the market, who was an agent with the Florida Department of Law Enforcement, people knowledgeable in this area, as reporters do. You take official records, you take them to sources, and you say, tell my readers what they mean, or tell me that they don't mean anything, and I won't write a story about them. They took these documents to these people, and these people said these look peculiar. And some of them used the word fraud to characterize the peculiarity that they found in them. Judge Williams correctly looked at the article. Judge Black, you asked exactly the right question. Was there anything that Ms. Weintraub provided? Is there anything in the record before this court to show that we missed anything, that we didn't provide the readers of the Herald Tribune with anything? And Mr. Harrison candidly answered, no, and that's the problem. They shouldn't have done anything. They shouldn't have reported anything. There was nothing left to not inform the opinion. We told the readers everything that we knew. We even put the records themselves directly online in complete fashion for everybody to see. Based on those records, 5 people in some fashion or another said these records look peculiar. And again, some of them used the word fraud. That basis, the factual basis, or a full disclosure in the newspaper, and the fact that we told the readers everything that these people based their opinions on, protects under the opinion privilege in Florida, the commentary, all of the commentary of these sources. Everything that we understand that Mr. Harrison has complained of, and I'm going to put a pin in that because we don't, even today, he's even said the whole article. He has to be very specific, obviously, in defamation law as to what he means. But everything he has raised seems to boil down to the word fraud, or a permutation of the word fraud, as it came out of the mouths of these sources, or as we, in leading up to quotes, as reporters do, gave a summation and then went into the full quotes. Those expressions are fully protected on the basis of the record of what we gave the readers, the record that is before the court. They're all privileged documents. He has admitted that they are all truthful renditions of the documents, and the only dispute is, as a matter of law, did we run afoul of defamation law in putting those words, putting their opinions in the newspaper? This court answered that question in the Rasmussen case again. The Rasmussen case involved the word stock fraud, and this court said that on the basis of all of the information given to the reader, Florida court protects opinions when the basis is known to the reader or reasonably available to the community, to the reader. And this court answered that question in the context of the word fraud in the Rasmussen case. This court was one of 5 courts in Florida that have dealt with the word fraud or something very much like fraud or the word peculiar in an almost analogous, perfectly analogous context. This court did that, not any of you, but this court did that back in 1984 in the Hay versus Independent newspapers when it held protected the word crook based on a criminal record where a man had been acquitted of certain charges, and a newspaper put all the information of what he was charged with and said, we still think that he's a crook, and if he wasn't acquitted, it was pretrial diversion, but it was some issue where he wasn't fully adjudicated as a criminal, and they used the word crook. The 4th DCA in 1988, in a case we've cited called Scandinavian World Cruises versus Urgel, held that a newspaper talking about the harbor master's fees in Port St. Lucie was milking the cow, and they put the entire basis in there for their phrase that he had been milking the cow, which is another way of saying fraud. And the court said in the 1988 decision in that case, the 4th DCA, that was entirely protected because the basis is entirely in the article. Deladonna versus Yardley, 1987, 4th DCA, same thing regarding a lawyer and an article about a lawyer in which it criticized the lawyer for feathering his own bed with fees, which is another way of saying a lawyer is committing fraud or charging elevated or fraudulent rates. And the 4th DCA, under the exact same protection, held that it was protected. More recently, in 2011, the 4th DCA in Fidelity Warranty versus First State Insurance overturned a jury verdict. It's one of the rare cases in this area that's ever even gone to a jury. Most of them fall out on summary judgment, as they should when we're talking about a free speech issue and as a matter of law issues. In fidelity warranty, the 4th DCA held that the words charging fraudulent rates to describe what a car warranty company was doing in a dispute with an insurance company in an oral conversation, not even in a newspaper article, where two people are having a conversation and somebody says, well, here are 5 things that they're doing. I think that's charging fraudulent rates. 4th DCA held that that was protected opinion. So there's nothing magical, nothing inherently warranting the denial of summary judgment, which is what he's arguing, when somebody talks about the word fraud or uses the word fraud in describing a lawyer's conduct, in describing a bank's conduct, in describing an insurance company's conduct, or a harbor master for that matter, so long as the factual basis is in the article, in the expression, in the record, and is undisputed. And here, it's entirely conceded and entirely undisputed. I think fairly stated what at bottom they're arguing for is that once we went to her and we asked her about extenuating circumstances, we asked her for an explanation. He characterizes it as badgering. We call it journalism. We call it asking questions of people before you run articles. If we hadn't done that, we'd certainly be here having a different conversation about that. He seems to feel that we should have stopped reporting. We shouldn't have gone forward with the story. Well, with all due respect, none of the law of Florida, none of the principles we've cited, none of the strong backing this court and Florida's appellate courts have given to the cause of journalism requires a reporter to stop asking questions or to forbear running stories that they think are newsworthy when they have gone forward and done all of their homework. And we brought to you a case that Judge Williams thoroughly looked at and decided that these reporters did their homework and that as a matter of law, summary judgment was warranted because it was protected opinion, because the undisputed facts are in the public record, and because Florida law protects this kind of reporting. If I can take 1 minute before I conclude, I'll also mention that we were denied summary judgment, or he disagreed with one grounds, and that's the public figure argument that we made.
Can I ask you a question about that? I'm glad you got to that, because can we even get to that since it's not part of the order on appeal?
Yes, Your Honor, you can. They mentioned in the earlier case, this court can affirm on any grounds that were raised below. Mr. Harrison is incorrect in arguing that we needed. So you don't have to file a cross appeal for us to entertain that? We do not, Your Honor. And I'll cite a few cases as precedent. State v. Hankerson, which is from the Florida Supreme Court in 2011, says that. The first DCA in Powell versus State, I would commend to your reading my former partner, Judge Makar's decision in which he talks about the tipsy coachman doctrine. Mr. Harrison cited a case from the first DCA. Powell expressly says that that case is no longer good law. And finally, under the Constitution, since public figure is a First Amendment issue, Bose versus Consumers Union in the U.S. Supreme Court says that it is the appellate court's duty to scour the record for independently to make sure that the trial court fully and affirmatively upheld the First Amendment. And in this case, we are asking you to alternatively or additionally ground your ruling in terms of public figure. And the factual basis for that is also uncontested. She was an active real estate attorney focused on distressed clients.
You're really at the end of your time. I think we understand what the public
Then
figure argument is.
We'll submit on the record.
Very good.
Thank you.
May it please the court. Carol Cicero again with Thomas and Lou Cicero. We represent SNN, which is a 24-hour news cable station similar to Bay News 9 in Tampa and Sarasota. The facts with respect to SNN are a little bit different but very simple. They're undisputed and all of record. SNN engaged in no original reporting here. SNN took the Sarasota Herald Tribune article, which it's entitled to do, reviewed the article, which on its face appeared reliable, heavily sourced based on public records, citing experts, talking to an FDLE agent, and based on that article wrote a very brief news brief that ran multiple times on SNN in its cycles about Ms. Weintraub and summarizing the Herald Tribune's reporting. It's clear from the record, we could begin citing page 25, paragraph 79 of the complaint, pages 825 and 826 of the record, which is the transcript of the hearing below, as well as page 13 of the reply brief. It's just undisputed that there was no original reporting by SNN. So in addition to and independent of the grounds that you've already heard discussed by counsel, the court can affirm the final judgment with respect to SNN on at least two other grounds. One of those would be the wire service defense, as it's called, that permits news organizations to report on reliable articles run by other news organizations. The other issue is a lack of a proper pre-suit notice to SNN under Chapter 770 of the Florida statutes. If I could briefly address the wire service defense, there's case law in the state that goes back to 1933 in the Florida Supreme Court that involves our own paper, the Tampa Tribune, and a report during Prohibition time about a congressman's secretary. The report was based on an AP wire service report that the secretary had been indicted for illegal possession of alcohol. And in that case, the court realized that Tampa Morning Tribune could not be liable for relying on the wire service report. That has been expanded. This court, in the McGregor decision that's cited in our briefs, recognized that you don't have to have a verbatim report. That wouldn't make sense to require news organizations to basically cut and paste other news organizations' reports in whole. Could create copyright issues as well. But you could get the gist of what another news organization was reporting and report that, and you would still be covered by the wire service defense. The McGregor case involved an article by the Miami Herald based on wire service reports. And then the Southern District was faced in the crazy Pulitzer divorce case down in Palm Beach with a Newsweek article that had been based on not just traditional wire services like AP reports, but on the reports of other publications, including multiple newspaper articles. And in that case, summary judgment was granted for Newsweek based on the wire service defense because Newsweek didn't engage in any original reporting on the issues. It summarized those prior articles. So in both the Lane decision, the Florida Supreme Court affirmed a dismissal. In McGregor, this court affirmed summary judgment. In the Southern District case, Nelson, the court granted summary judgment there. The wire service defense is well established in Florida, and it typically goes out on pretrial motions. So when the court looks at what SNN did in this case, the wire service defense protects its reporting and is an independent ground under the Tipsy-Coachman doctrine for affirming the final judgment with respect to SNN. The other issue that we've raised that's unique to SNN somewhat is the pre-suit notice requirement under Section 770.01 of the Florida statutes. It's a very specific notice requirement. It applies to TV stations as well as newspapers and requires that the plaintiff or potential plaintiff specify statements that they claim are false in the reporting, and it has to be done, quote, before a civil action is initiated. That didn't happen here. A letter was addressed to SNN, but it went on for 16 pages about the Sarasota Herald Tribune article, and with respect to SNN, it says, quote, these matters were broadcast or republished repeatedly between February 16th and 18th, 2014 by SNN, and that's all it says. So it's an insufficient pre-suit notice under the very language of the statute that's in play, and it violates also the case law that we've cited in our brief, including the Orlando sports stadium case out of the 5th DCA, that requires specificity. We're not asking for verbatim quotes of what was telecast, but something more than just you republish some subset here that's not identified is required. That had to be done before a lawsuit could be filed against SNN. You cannot amend. They would have to...
Ms. LaCicero, you're about at the end of the time.
Okay. Your Honor, they would have to this lawsuit would have to be basically started all over with respect to SNN to satisfy those requirements. So we would ask that for the many reasons raised in the briefs and in the arguments today, as well as the wire service defense and the violation of 770, that the final judgment against SNN be affirmed. Thank you.
Thank you. Mr. Harrison, you have 3 minutes for rebuttal.
Thank you, Your Honor. On the fair report privilege, let me be very clear, because we are not asking the court to create an exception to that doctrine. What we're asking the court to do is to apply the doctrine only to the extent that the purpose underlying it is furthered. You ought not apply a privilege to protect the media if the purpose that underlies the privilege is not being furthered, and there's no purpose to the fair report privilege here. Counsel has even indicated, again, in the cases he cited, everything reported on was some statement or some document issued by the government. You don't have that here. All you have is a clerk who performs the ministerial act of recording a mortgage. It doesn't matter that that later becomes the basis for foreclosure. That's not what gets them the privilege. And in the Firestone case, the Supreme Court said, even though an essentially private matter ends up in court, in that case the Firestone divorce, that doesn't mean it's protected. So we're not asking for an exception, we're asking for the privilege to be limited to the purpose it's intended to further, which we don't have here. On the public figure question, I'm glad you raised that, Judge. We don't think that the court can or should get to that. The distinction is it's not simply a matter of affirming on some other ground that may appear in the record. They are asking for, and the court would have to grant, affirmative relief from a part of the order. Judge Williams found that Ms. Weintraub is not a public figure. The court would have to reverse that portion of the order, granting them affirmative relief in order to get where they want to go. And when you're seeking affirmative relief, the rules require a notice of cross appeal. That's our position on that. Again, on this broader question, you heard Mr. Tobin say again, we should be protected because we revealed all the facts. We put all the facts in the article. Well, that's maybe sort of true, but what they put in the article really was the fact that they had no facts on the extenuating circumstances. None of their supposed experts, by the way, when you look at these statements, and they didn't say it looks peculiar. They said it's fraud. Mr. Weidner said something like, the feds have prosecuted for much less, this lady has a big problem. The clear implication is that a crime, a serious crime, was committed. Nobody said it looks a little strange, it looks a little peculiar. They didn't have all the facts. They couldn't report all the facts because they didn't have them, and that's the dilemma. Should a private citizen be required to lay bare her financial life, her personal life, her potential health or medical issues in order to avoid being defamed? That can't be right. That can't be right. So if you don't tell them, you get libeled in the paper, and if you do tell them, your neighbors are reading out in the next day about your personal financial situation or your medical issues or your family issues or whatever the case may be. That can't be right.
And Mr. Harrison, you need to conclude.
Thank you, Your Honors.
Very good. Thank you. We're going to take about a 10-minute recess, and then we will continue with the last two cases on the oral argument document.